Thank you.
This is an appeal in the matter of Pickering Fishery Association and Secretary of State for Environment, Food and Rural Affairs.
Yes, Mr. Kimberlin.
May it please the court, I'm here on behalf of the Appellant, Secretary of State in this matter with my learned friend Pinden. Dr. Wolfe appears first respondent Fisheries Association with my learned friend Mr. Desai. Mr. Fraser is here for the second respondent Environment Agency.
Good. Thank you. We've got an array of folders which have been revised, I think, somewhat in recent weeks. There seems to be a possible snag of the authorities bundle, which I'm sure won't be insurmountable. I think some of the page numbering may have gone awry at the end of volume 1, the beginning of volume 2.
I agree.
So rather than attempt some sort of elaborate housekeeping exercise at this point, just to note that when we get to those pages, clear referencing to which folder we're in will help.
I respectfully agree.
The other matter that is on our housekeeping agenda is Mr. Scott's third witness statement.
Yes.
As far as we know, that application, which was made in April last year, remains to be dealt with by this court.
Yes.
We may have missed something, all of us, but none of us has been able to isolate any reaction to that application from other parties. Is there any?
That's probably best for others to deal with.
Well, I think we've indicated in email correspondence with the court that we're content with it being admitted.
Right.
Apologies if that hasn't reached us.
No, well, there's no need to apologise at all, because I'm no doubt that what you said is right, and it simply hasn't come through to us. At least it hasn't come through to me, I don't think. But Mr. Fraser, do you want to say anything about this?
My Lords, nothing really to add to what is in the application notice, namely that the witness statement is intended to assist the court on a number of factual matters.
It does give rise to some concern in our minds. It contains a good deal of factual information which might, it may be said, have been provided to the judge and the court below at the time of the hearing.
Yes.
And given that we are determining issues of law on this appeal and not in any way resolving issues of fact, that does give us some cause for concern. We do feel, I think, that such evidence tendered by way of further witness statement after the hearing in the court below is unusual, to use a neutral word, if not actually wrong in principle. On the other hand, there may be material in there which in the course of argument becomes useful to the court. So that leaves us with something of a dilemma. It's the kind of dilemma that can be addressed by receiving the evidence de bene esse. I'm not sure what English expression ought to be used in place of de bene esse, but de bene esse, in other words, receiving it without reaching a concluded view about it until later on. We shall need to reach a concluded view about it. But for the moment, that may be the way forward, given that the evidence is not resisted. But as I say, as a matter of principle, it does give rise to some concern, and I'm not in any way promising that we won't reach the view that as a matter of principle, the evidence ought not to have been tendered to the court. Peter, do you want to say anything else in the light of what I've said, and then we will consider the position. But I don't want time to be taken unduly over what is if not uncontentious, at least unresisted evidence before the court.
My Lords, I have nothing further to add. I'm entirely content with that approach.
Well, we'll receive it de bene esse and see how we go. We will need to resolve ultimately what its status should be. We'll receive it for now de bene esse.
I'm grateful.
Right, yes, Mr. Kimberlin. I should have said, well, I shall say now, thank you very much to all counsel for the skeleton arguments we've received, which have set out the respective positions of the parties. We are, of course, familiar with the contents of those arguments, with the judgment in the court below, with the legislation, which is largely, I think, the centrepiece of this appeal, by way of its proper interpretation. So you can assume all of that for the purposes of your submissions. Is there anything else we need to deal with before you get going?
Just one thing, if I may. The programme of measures, which is in tab 3 of the supplementary bundle, is printed very small. And so on your desk, there is, in a plastic wallet, the same material at A3, which might be just about legible.
Yeah, it is. It is rather reminiscent of a visit to the opticians document.
I remember a spoof practice direction in a county court which directed that any document that was key to a case shouldn't be legible.
Right. Well, this does help because
does.
This is at A3. It's been numbered as well, so I will simply insert that. And thank you for doing it.
There is, in the authorities bundle, one document which suffers from the same defect. We're in the process of correcting that, but I won't take any time with that.
All right.
That now.
Well, we've done that.
So, in the light of my Lord's helpful indication, what I will say in addition is that with his typical cooperative approach, Mr. Wolf and I have discussed timetable.
Yeah.
We note the time estimate for this case. We're confident about that. The staging posts involve my completing my submissions. By the end of this morning, I would have thought maybe going just beyond lunchtime. The objective is to have Dr. Wolf on his feet during the course of this afternoon. He'll be continuing those submissions tomorrow, perhaps. In fact, I'm sure. But we've had that conversation, and I hope that that's the way that things turn out.
Well, this is a day and a half, this
It
hearing,
is.
and we will be concluding it no later than 1 o'clock tomorrow.
Exactly.
So you'll need all of you to cut your cloth according to that.
Just to reassure the court that that conversation has been had,
Yeah.
and we're very clear about the time estimate.
It's a day and a half. We're finishing at 1 o'clock tomorrow,
Thank you.
or no later than that.
The issue is capable of being relatively shortly stated. Indeed, we needn't turn it up, but the judge does that at paragraph 128 of her judgment. And the issue, central issue, is really the question: does the Water Framework Directive require the periodic review of the programme of measures must be undertaken for individual water bodies and set out such measures for each individual water body? That's really the question posed at the heart of the case.
Yeah.
And in that regard, there are 4 terms within the directive which I suggest will be prominent in the submissions which the court is going to hear.
Yeah.
The concept of the River Basin District, within which one finds very many individual water bodies. So first term, River Basin District, second, water bodies. And the 2 other terms which will be very prominent will be the environmental objectives and the programme of measures. and the case is about the interaction between those things and those concepts.
Yeah.
Well, may I say at the outset that the directive brings with it all sorts of interesting questions which the courts have not addressed. There isn't very much case law on this directive, in contrast to several of the environmental directives which are heavily litigated. This one isn't. But what I say is there'll be many interesting questions which we will leave unanswered at the end of the case. But the focus of this case is the issue which I have just sought to identify. And my submissions are very much focused on that key issue. And the structure by which I propose to make those submissions is again fourfold. Firstly, as to purpose, and I don't think there's any dispute or discussion to be had about statutory interpretation and the importance of purpose. So firstly, as to purpose. Secondly, I want to focus upon that part of the directive which is particularly concerned with which is particularly concerned with point sources as opposed to diffuse sources of pollutant inputs into waters. And the function of doing that is to provide an opportunity for the court to see the workings of the directive in particular context, not least because one of the particular concerns of the Fisheries Association is point sources, sewage treatment works, etc. That's the second part. Thirdly, I'll turn to the terms of the directive itself. That may seem slightly frustrating to have to wait until that stage to actually turn up the directive itself, but it's in that, having looked at the purpose and illustrated what one sees in the Framework Directive, I turn to the key provisions in Articles 4 and 11 and the important annexes at 6 and 7. And fourthly and lastly, I'll turn to the judgment below. I don't propose to say very much in opening in respect of such case law as the parties' researchers have produced.
Right.
In terms of the documents that I intend to work from, will be heavily focused on the supplementary bundle and primarily the second volume of the authorities bundle. Though, of course, one finds the directive itself in the first volume.
Yeah.
So far as purpose is concerned,
Yes.
I propose again by 4 particular types of documents to look at the purpose of the directive. The first is...
It will help, sorry, you're probably going to do this anyway, but I'll just mention now to help you. You set out 4 headings just now, which I've noted. It will help me, at least for the purposes of my note, just to have a flag of those headings as you come to them. So here we are, first purpose.
Thank you very much.
Yeah,
yes, of course.
I'm sure you're going to do that anyway.
And can I just add, and I'm sure you're going to do this as well, when you're dealing with the regulations as well as is that going to be in the same part where you're dealing with the directive?
Yes. I will pick up some of them while I'm dealing with point sources.
Are you going to cover what actually happened with this plan and programme of measures?
I am. While I'm dealing with point sources, yes.
Yes, you may need to look at it more widely than just point sources.
I may, and
because this touches on the third witness statement of Mr. Scott.
Yes.
And trying to help the court understand what was actually done.
Yes.
Thank you.
Yeah. That's right.
So far as purpose is concerned, Firstly, first in time, that there are some statements of intention prior to the directive, which I want to turn to. We find out something about the purpose, secondly, from recitals. Thirdly, we have some European guidance to look at. And fourthly, there is, of course, the Secretary of State's guidance. The third and the fourth, the guidance documents, of course, post-date the directive. And as I've indicated, through those, I'm going to particularly identify those four important features of the directive: the programme of measures, the river basin districts, the water bodies, and the environmental objectives. If we could deal then with what I've called as a category, the statements of intention. If we could turn, please, in the authorities bundle to, I think it is in the first volume, in the authorities bundle to tab 19, tab 19, which commences at page 607.
Yes.
Where the court will see that this is a communication from the Commission, and it's a communication on European Community water policy. And it is an important document which sets in train the ultimate adoption of the Framework Directive. And we learn that from page 611 in the introduction, where in the third of the three introductory paragraphs, we're told that this concentration on environmental aspects of water policy is reflected in the main conclusion of this communication, which is referring to the Environment Action Programme, after the semicolon, the need for a Water Resources Framework Directive. There it was referred to as a Water Resources Framework Directive. It became the Water Framework Directive. So there's a need for it. And what we see in terms of what it is aimed at, it is set out over the page at page 612, where section 4 addresses the challenges. So what were the challenges which were sought to be addressed? And in respect of pollution, two sources of pollution are set out: point source pollution and diffuse source pollution. The remaining three headings are concerned with effects or ways in which such pollution might come about, accidentally, acidification or eutrophication. What is also important to immediately understand in terms of what the objective was is that the point in time at which the Framework Directive was conceived as an idea, that there was already a substantial body of European law in this regard. And we see at page 627 going through to 631 is where I'm going to come to. We see at 627 that there's an outline of the Water Resources Framework Directive, but it sets out for us a list of directives, second paragraph at 9, which would remain largely unaffected, although the Commission will consider the scope of transferring some of their definitions, monitoring requirements, and other relevant elements into the framework. And we see, for example, there mentioned the Dangerous Substances Directive. Then turning the page 6 to 8, in the middle of the page, starting at the top hole punch, the Framework Directive would require integrated water management planning on a river basin basis. And there are set out a number of bullet points which we will see strongly reflected in the framework when we come to it. Monitoring, assessment, objectives, programme of measures, consultation, then monitoring on implementation. You'll see that strongly reflected. In the annex at 630.631, the reason I took the court to the list of directives is that there is here a more expansive list of directives which concepts of which have made their way into the framework. And I highlight only one, 1.3 on page 631.
Just noticing on page 628,
Yes,
penultimate paragraph on the page, within the river basin, the nature of the objectives and measures may vary spatially. And just before we leave the document, on page 613 to 411, etc., these are measures being solutions. But 4.2, one of the challenges is water shortages
Yes.
and abstraction.
yes.
So this is a holistic exercise.
My lords, I respectfully, strongly agree, because, as is submitted, particularly in the appellant's response to the OEP's intervention, we submit strongly that we're here concerned with interacting features of the basin, including groundwater. We're not going to spend time on groundwater, but in many basins it's highly pertinent to matters of quantity, which my lord has just diverted to. And the interaction between those is something which the framework seeks to grapple with. And as to the point that the court's taken me to in respect of objectives and varying, that of course...
Well, it's not just the objectives, it's also the measures.
Well, if I deal with the objectives first, necessarily that the objectives are going to vary across the basin because they are water body focused. And we will see in due course when we come to the Costa Beck, we will see that for the Costa Beck, particular objectives are identified and the current status is identified. So absolutely it varies across the basin. But as to varying of measures, that's a point which I'll come to in due course, if I may park it. So far as just wanting to flag dangerous substances, because it's a point that we'll come to in due course. Page 631.
Yeah.
Dangerous substances are controlled, and that is something which has been in place for a long time. And we see just at the end of 1.3, the sentence at the end of 1.3, the directive contains two alternative methods of setting these conditions. Choice between applying emission limit values, or they can base their permits on limits required to meet quality objectives. So permits, a particular permit, you can have a concentration X being discharged, or you can have a quality standard. You have to meet this standard in the relevant water body. So there we have the document which really starts off the journey which takes eventually...
So I'm not quite sure I'm following what the drift of your submission is. There are two alternatives in that sentence. Are you saying that the first alternative is not necessarily specific to a water body, Is that the reason why you're taking us to that?
My lord, the reason I'm taking that, I'll be very straightforward about why it's important to understand that at the outset, and I'll come to this in due course. In the same volume, we have the River Basin planning guidance from the Secretary of State, which is at tab 17. Tab 17. This is guidance which I'll come to later on in the submissions, but to answer my Lord Justice Holgate's question, what I'm doing is setting up an understanding of the difference between the two things which we see on pages 520 and 521, 520 and 521, where the court will see that, I don't know whether these are sections or chapters, I'll call them sections. 520, there is a section 9, which is addressing environmental standards. And at section 10, it addresses environmental objectives. To answer my Lord's question, I wanted the court to see the origin of the distinction between environmental objectives and environmental standards. And so for the emission of a particular chemical into a water course, let's take the example of phosphorus. There may be an environmental standard, which will be a number. We'll make the number 1. The environmental standard on any permit might require that the emission of phosphorus doesn't exceed the number 1. Equally, there may be an environmental quality standard for the water body, which requires that the water body meets a particular environmental standard, make it the number 5. Those are environmental standards. And part of the origin of environmental standards are directives such as the Dangerous Substances Directive and other related directives which affect regulation of what is emitted. It may be that there are complete bans, it may be that there are controls on concentrations discharged or controls on concentrations which are the targets for a particular water body. So that is, I apologise for not making the focus of that submission as clear as it should have been when I made it, but that is something which I need to just draw attention to while turning to that document.
Right. So that's your answer to my Lord's question.
Yes. So that is all I proposed to do in respect of the originating documents. I turn now to the second part in respect of purpose, which is some recitals. And
Are we putting these documents away now?
my Lord, yes, if we can put, we will need the authorities bundle, tab, the authorities bundle for reference to the directive. I'm now going to take the court to the directive for the purpose of looking at the recitals, so tab 1, noting of course my Lord's indication that the court has read the key legislation here. So far as purpose is concerned, I would like to take the court, please, to certain of the recitals so that we can understand what it is that was being sought to be achieved. So far as substantive purpose is concerned, I'd like to take the court to 5 of the recitals. Page 5 actually, no, I apologise. Page 6 is 13. I'm going to go to 13, 26, 33, 36 and 38. So 13,
So you want 5, 6,
so the recitals I propose to take the court to are 13, 26, 33, 36 and 38.
right. So 13 first.
Top of page 6, I'm grateful. Rather along the lines of my Lord Justice Holgate's point about variation across basins, there's also variation across the community. And second sentence, this diversity should be taken into account in the planning and execution of measures to ensure protection and sustainable use of water in the framework of the river basin. And so what this does is highlight that the framework by which one takes account of diverse conditions is the river basin. And that's why I emphasised it as one of the 4 key terms right at the outset. And decisions should be taken as close as possible to the locations where the water is affected or used. Priority should be given to action with the responsibility of member states through the drawing up of programmes of measures adjusted to regional and local conditions.
What does that mean, actually?
Well, my first answer to that question is that it doesn't mean or have any relation to individual water bodies. That's the
What are
first thing.
local conditions?
That is by reference to the conditions in that part of that member state. Because what the recital is recording is that there is very significant variation in conditions across the community.
Right, so look, what you're really saying, if I've got this understanding wrong, just correct me, is that local conditions doesn't descend beneath or below the level of river basin.
That's my submission.
So what would regional conditions be?
Regional conditions is rather analogous to river basin districts, and one sees that in the way in which it plays out within the UK. At some point we might turn up a plan, but when one looks at the scale of the river basin districts in the UK, it's very easy to recognise regions. They look like regions that you would be able to describe.
So local conditions as river basins and regional conditions as river basin districts.
That's a helpful way of understanding it, but it ultimately little turns on it. What we have here is a recital which is explaining that conditions vary across the community, and the sorts of measures which you need in a drought-hit part of Spain are going to be different to those which you're going to be interested in within the Highlands of Scotland.
So just to pursue that last point, if I may, I don't want to cut across what my lord has asked you, but just to clarify the answer you gave, are you saying that geographically regional and local are synonymous?
Am I saying that regional...
You seem to distinguish between a river basin district and a river basin as such. Unless I misunderstood what you were saying, that is what I think I heard you say.
Yes, and I'm to pick up on that point, I'm bound to say that a river basin district is larger, maybe regional. A river basin district is larger than a river basin because one has one has a number of individual river basins which will make up a river basin district. You
But
can-
it's
you can
page
stick-
13, isn't it?
Yes.
Article
Right.
215.
Exactly,
It's made up of one or more neighbouring river basins.
exactly,
So it may be SoS, it may be multiple.
Right, so that's the answer, is
yes. I
That's
respectfully agree.
the reason for the district is it's you're just selecting a geographical area for the convenience of administration, as opposed to the pit basin referring to what exists in the real world.
I would respectfully agree that it is administrative, and it's an important part of the directive to have administration. It's a rather bland
Basically,
term.
it refers to the main unit for management.
Main unit for management, absolutely,
Whatever the geological or hydrological features may be.
yes. But there is a but, which is that river basins adjacent to each other may form part of an overall catchment, which all drain in the same way. And that's what we see in this particular river basin district. So smaller basins aggregated into one overall basin, one catchment. You know, if you refer to a basin as a catchment, a number of catchments together making up a river basin district. But what is essential from this recital is that it is concerned with river basin districts, not individual water bodies, and the concept that one's going to adapt appropriately across the community. Which takes me to 26, which is on a similar point to those which have arisen in questions already. 26, bottom of page 7. Member states are aiming to achieve the objective of at least good water status. So we've had river basin districts, we've got programs and measures, and now we introduce the objectives. Within integrated programs of measures taking into account existing community requirements. So there, I emphasize integrated programs of measures, so that already the recitals are dealing with programs of measures which are intended to be integrated across the river basin district. That too is reflected in the next two recitals, 33, again referring to good water status. The last two words are coordinated, so the objective of achieving good water status should be pursued for each river basin, so that measures in respect of surface water and groundwaters belonging to the same ecological, hydrological and hydrological system are coordinated. Again, going back to my Lord's point about administration, the way in which one plans such measures. But we also see it in respect of recital 36, where the characterization of river basins is the topic. So, first step, understand the basin by characterizing it, including impacts of human activity. The development in water status should be monitored by member states on a systematic and comparable basis throughout the community. This information is necessary in order to provide a sound basis for member states to develop programs of measures aimed at achieving the objectives under this directive. And so there is, again, because we've got integrated, coordinated, and here we have a sound basis, a comparable basis, so integrated, coordinated, and comparable. The programs of measures are focused, as we see here, on the characteristics of the river basin, not the water body. And that understanding, that analytical work is what informs.
But does the recital assume that the characteristics of the river basin are uniform across the basin?
No.
So, if that's right, then this is neutral on the issue the court has to determine.
My lord, I wouldn't accept that. What I would submit is that the recital, and in particular the way in which we've read these recitals together, is focusing on the basin. If the opposite were true, then one would reasonably anticipate that by now we would be told something about what we are to do with programmes of measures and water bodies, and we haven't. Which leaves me with 38. 38 is on the topic of economic instruments. I'm not going to say very much in the course of my submissions on this part of the directive, but nevertheless it is there and an important aspect to both understand and to plan for the way in which water resources are used as to the recovery of costs for water services, etc. The purpose for going to 38 is solely this, in respect of the last sentence, because it too refers to river basin districts. The economic analysis of water services based on long-term forecasts of supply and demand for water in the river basin district will be necessary. And given the fact that we're concerned with the operation of the basis as a hydrological unit interacting quality, quantity, surface and groundwater, what one sees is that the purpose of the directive is to approach these in an integrated way based upon the river basin and the river basin district, not water bodies.
There are references, of course, aren't there, in these recitals to bodies of water,
Indeed there are.
water bodies and so forth.
Indeed there are.
Are you going to introduce us to any of those references?
I will do so. I'm going to come next to two recitals which deal not with substantive purpose, which all of the ones I've just been to are. I want to just alight on two which deal with mechanisms, and then I'll come to my Lord's question as to water bodies.
Right.
So as to...
You're going to draw out the distinction between purpose and mechanism, are you?
I am. At recital 10, these early recitals are concerned with the history of the document. And at recital 10, we have the link there to the document, which I took the court to at the outset, prepared by the Commission. And what the mechanism is, as we see from the last three lines, is that it's a proposal to establish a framework for European water policy, so that the mechanism is to provide for the community a framework to be implemented in a variety of ways, with subsidiarity principles in play in different ways in different member states. And that point as to the mechanism is also echoed at the 18th recital, page 6. Community water policy requires transparent, effective and coherent legislative framework. So what this instrument is creating is a legislative framework, and that the community is providing common principles and an overall framework for action. Now, to deal with my Lord Senior President's question, I turn first of all to recital number 40, and 40 needs to be read through to 45. It's 40 to 45 are a little section of recitals which deal with my Lord's question.
Right.
40 talks about pollution prevention and control. You can control the pollution at source. And in 41, in respect to quality, sorry, in respect of quantity, there's also the control there of abstraction licensing. So the two going together. 42 is the reference to standards, which is why I took the court to the material I did earlier on. There's
It's
also
interesting that refers to standards as minimum requirements.
yes, I respectfully agree that the requirements of the directive in respect of standards are noticeably different to the requirements in respect of objectives. So it then goes on at 43 to address pollution through discharges. At 44, the hazardous substances point is identified. And 45, explaining that member states are to adopt measures to eliminate pollution. And in the last two lines there, for achieving the objectives for the bodies of surface water. So at 45, we get to the answer to the Senior President's question. Member states should adopt measures to eliminate pollution of surface water by priority substances and progressively to reduce pollution to other substances that would otherwise prevent member states from achieving the objectives for bodies of surface water. So one sees the interaction there between standards and objectives.
Do you distinguish objectives from purpose?
I distinguish.
Well, you introduced this section of your submissions, or subsection of your submissions, as it were,
My Lord,
by
yes.
saying you were going to distinguish between purpose and mechanism.
Um,
And when we get to a word like objectives, I begin to wonder whether that might come close to the category of purpose.
the objective that is referred to there must be understood in the context of the way in which objectives in the framework are defined.
Yeah.
And in due course we'll see that. So it's very much focused on the environmental objective of the directive, which ultimately is good surface water in water bodies.
Yes. There's nothing to be remarked upon, and it's not saying objectives for the river basin
My Lord, no, I didn't.
or river basin district.
My Lord, I'm not going any further than that.
Right. Were you going to take us to 31?
So the upper Costa Beck is a particular type of water body in that it's heavily modified, a term in the directive, and 31 is concerned with such a type of water body.
Yeah.
Those cases where the water body is so affected by human activity or its natural condition that you can't get to good. That's paraphrasing, but that's what it's about.
So how does this fit into the scheme, if you like, of these recitals? 31.
31 fits into the scheme of recitals by the community recognising that there will be water bodies in which there is a tension between the current physical characteristics of a particular water body, which may be there for a important purpose, removal of which to get to a point where you meet the environmental objective brings with it such cost or other adverse consequences that it's not desirable that that be done. So that's the purpose of 31 is to recognise that there are some water bodies where it's not appropriate to take measures to modify or to restore the water body in its physical characteristics. And so there may be a weir, there may be controls on the course of a surface water course. It may have had its course altered by human intervention for perfectly sound reasons, removal of which is not feasible, and by that reason it may be heavily modified. So those are the recitals to which I propose to encapsulate how the framework itself sets out what it's trying to achieve and something about how it's trying to achieve it. Next, in terms of purpose, third out of the fourth approaches, is material which is produced after the framework was adopted. And that is the common implementation strategy. And if I could invite the court to switch authorities bundles to the second authorities bundle, and noting my lord's gentle indication that pagination and tabs don't quite work at certain points.
Yeah.
Towards the back at tab 23,
Well, just to, don't want to take up time on this, but there's about 1,000 pages here which are not indexed, running from page 893 through to the tab 23. Now, I'm not supposed to be looking at them, so we're going to need to know what it is.
there is some replication, which makes
I
it.
gave up
Yeah.
Anyway, I'll leave it there. But sorry, you're taking us to is it tab 23.
Tab 23,
Thank you.
1796. The foreword is on 1799. That's probably the easiest one to read.
So this is the common implementation strategy.
My lord, yes, there is. There was a project. There's a project which is explained in the foreword. It's top of page 1799, which explains that right at the top of the foreword that EU member states, Norway and the Commission have jointly developed a common strategy for supporting the implementation of the directive. So that is the CIS, which is made up of a number of documents. This is guidance document number 11, which is focused on the planning processes. So that the court isn't misled as to the status of the document. At 1798, there is a disclaimer. The disclaimer tells us that this technical document is being developed through a collaborative programme involving the Commission and Member States, etc. It's regarded as presenting an informal consensus position on best practice agreed by all partners. However, it does not necessarily represent the official formal position of all of the partners, nor necessarily represent the views of the Commission. However,
On the same page, we're told that this is the product of a working group.
yes,
And is this document being approved by Superior, or whatever the working group is?
yes, it is approved and adopted by the Commission and the member states,
Really?
Where do
we see that?
subject to the contents of the disclaimer. So the reason I put it like that is that the CIS, a suite of documents, is an extremely important set of documents which underpins the practical application of the directive in a wide variety of ways, and it's followed. But the reason that I take the court to the disclaimer and the foreword is that I don't want the court to be misled that this is Commission guidance. So in other contexts, one has guidance created just by the Commission.
So the UK's involvement in this is where?
As a member state in producing this document, because the UK was a member state
A
in
member
2000.
state at that time, and its status now?
And it continues as the relevant strategy to be applied across the community.
Across the community?
Yes.
Yes.
And as a matter of practice, it's used in the UK.
What's the link to that last proposition? It is used in the UK, is what you're saying.
Yes.
It's also a living document requiring continuous input and improvement, isn't it?
Yes,
Obviously, is the final paragraph on 17.
exactly. Yeah.
So as a living document, is there a later iteration of it, or has it just developed as a living document in the last 20 years and we still go back to the 2003 version?
I'm not aware of any update to this guidance document number 11.
It seems also in the same paragraph to be focusing on implementation of the directive.
Yes.
So implementation, not interpretation, which is a question of law. Application, if you like.
Yes, and there's case law that addresses that distinction.
Well, certainly in the domestic context,
Yes.
and I did wonder whether there's any European jurisprudence which would help us to work out what is the status of this document. I mean, also we have page 1802, top paragraph, giving guidance to the competent authorities.
Yes. Can I put it this way?
It's like a practice document. You can see the middle of the page.
It is a document to inform and guide member states in putting into effect the framework in a way which is common across member states. And as my lord will see when I take the court to particular parts of the document, it does the job, in fact, of explaining what the framework is intended to do. So it does, in fact, assist with interpretive questions. The remaining,
It's a commentary
it is.
to that extent.
It is. I respectfully agree.
And would it be right to say it's a commentary of what would be expected or required at national level?
It is.
I'm looking at 1802, the last sentence of the top paragraph. Management tool to implementation at national level.
Yes. And that's very much the function, so that at national level there is an approach which is a level playing field, and that those who are tasked with managing the water environment go about it in the same way.
And what have other member states done then? By way of parallel activity to what we see in the present case. It guided by this guidance, which has been extant since 2000.
So if I understand my lord's question in terms of the activity
Yeah.
that relates to this, that there is a substantial liaison between experts in member states.
Yeah.
It's an expert question as to how one goes about both planning and also in respect of monitoring and setting environmental objectives. And so it is the very production of documents such as this result in a high degree of interaction between, in the UK we have we have the competent authority and agency. So at that level, one sees those interactions, and elsewhere in the papers, one sees the individuals named from who are representative of each country. So it's an exchange.
But what I really had in mind in asking the question, which I think was a very broad question, was the issue that you've defined for us on this appeal. I mean, how have other member states, guided by this guidance, addressed that issue as to the level of, if you like, the level of particularity that is required?
The short answer to that question is that no member state takes the approach which is the result of this judgment.
We'll pick that up in any of Mr. Scott's witness statements, but I dare say you can give us a reference later.
Yeah, well, it's a negative, and the point has been made throughout. And if the contrary position is advanced, I'd be happy to deal with it. So from the contents page, it's at 1801. We see a section 5, which deals with the specific requirements in the directive with regards to the planning process. And what it does is sets out components, 1st through to 9th. So 5.2 through to 5.8. Oddly, the contents page misses out
The second.
So what one has there, in the contents page 5.2 through to 5.8, the 9 components. So for some reason, the contents page has missed out the second, which is environmental objectives, quite important. So what I'm going to do is take the court to 3 of those components, consistent with what I said at the outset, was particularly important in this case. The second, not appearing in the contents page, environmental
But it
objectives.
is there on page 33, isn't it?
It is there. It's absolutely there. The second is environmental objectives. The 5th, programme of measures, and the 6th is river basin management plans. So, as my lord is already miles ahead of me, if we could turn to using the through pagination.
The curious thing is, and we need to perhaps to have this in mind when we approach this section, 5.1 gets used again for the second component on page 33, having been used already for the preceding component.
Exactly.
Something odd has happened and it's got missed off the index as well.
Maybe it's a living index.
Life of its own.
Yeah.
So, as my lord indicates, internal page 33,
Yeah.
1034 over to 1035 is environmental objectives. And so, short indication is that the second component in the implementation of the planning process includes the setting up of environmental objectives. It mainly is based in Article 4. So we, in due course, will be going to Article 4. And in terms of my submissions about what the purpose of the directive is, I want to draw attention to what we're told the main aim is of environmental objectives. On page 1835, in the penultimate paragraph starts, the main aim of the definition of environmental objectives is to set goals and targets which then serve as the foundation of the decision on programs of measures. Goals and targets should fix into a long-term vision for the River Basin District and be seen as steps to achieve the vision via a concrete planning process. So the main aim is by reference to the River Basin District. This document doesn't set the main aim for environmental objectives by reference to individual water bodies.
Except when you come to the next paragraph.
But in the next paragraph, environmental objectives are dealt with by reference to water bodies, and they must be, because that's what the directive.
Well, that's what I was going to ask you. I thought it was common ground, that the legal obligation to set environmental objectives
Yes.
is specific to water bodies.
And that is common ground.
That's Regulation 13.
Absolutely.
Oh, okay.
Yes. So, but may I grapple with that? Because what we have in those two paragraphs is a key distinction. It's a key distinction between what the programme of measures is doing to assist with the aims of the framework, and something else, which is the environmental objectives for the particular water bodies. And if one just puts those two things together without drawing that distinction, the distinction which is clear from the two paragraphs, then one makes the error which is at the heart of this case, that you have then turned the programme of measures into something which it is not intended to be. It is, of course, a point which I'll have more to say about.
So the sentence you're emphasising is the first sentence, is it the main aim sentence that you took us to?
My Lord, I'm not emphasising one sentence or the other. I'm reading that paragraph as saying that the main aim relates to using programmes of measures to assist in the long-term vision for the River Basin District.
That follows on subsequently, but we're being told, before we get there, that the environmental objectives, their main aim is to set goals and targets which are the foundation for the programmes of measures.
Yes.
So wouldn't that support what the judge said here, that the programmes of measures are based upon the environmental objectives? And if they are water body based, then so may the programme of measures be.
Well, to a degree, that's always going to be the position, I'd respectfully submit, because that when one has a river basin which is made up of very many thousands of water bodies, one has conducted an analysis of the basin to understand what the pressures are. That's what the directive does. And the programme of measures is aimed at those pressures, which are manifested, of course, within individual water bodies. But that does not mean that the programme of measures is focused on a particular individual water body. And all of the material which we've been to so far says that it's focused on the River Basin District. That, of course, has a strong interaction and a purpose, an obvious purpose of promoting, supporting, and ultimately achieving the environmental objective for the water body. But it does not, in my submission, mean that the programme of measures is something which focuses on the water body. That point is further clarified and supported if we turn, as I said we would, to what this document has to say about programme of measures and what we learn in terms of purpose from this fifth component at 1839. 1839 is setting up the programme of measures. It's a longer section, as perhaps one might anticipate. What I'm inviting, well, I'll just deal with the first paragraph so we understand what the function of this component is. The fifth component in the implementation of the planning process is the establishment and implementation of the programme of measures. And I emphasise in particular the second and third paragraphs. The directive requires river basin plans to integrate the management of quality and water resources, surface and groundwater management in order to meet the environmental objectives. So consistent with the recitals that we've already seen, integrating those different aspects of the hydrology of a basin and linked to environmental objectives. Next paragraph, how is that done? Is that done by reference to programmes of measures for water bodies, or is it by reference to districts? The programme of measures to be established by the end of 2009 will consist of defining for each district, which I emphasise, the regulatory provisions and the basic measures to be implemented in order to achieve the objectives defined for 2015 by the management plan in accordance with community and national laws, etc. So again, as we see consistently through the materials that we've been looking at, the focus is on the district.
Well, and even the last sentence says measures may be decided on the national level.
Absolutely.
Which is in Article 11 itself.
Absolutely. And
it isn't necessarily river basin related.
Which assists my point.
Yes, but maybe this is not being prescriptive as to level at all. It could be either national or river basin. It may also be water body level.
The judge's finding is that the conclusion is that one must address water body level.
She said it can't be excluded.
Yeah, and what I'm submitting is that the focus of the programme of measures is the basin, and all of the material supports that. My Lord's question as to national measures inevitably flows from the terms of the directive, because the directive includes other legal instruments, and that is why my next topic, to which I'll come to relatively shortly, is point source pollution, which is perhaps the best example of a national measure through the 2016 regulations. So I'll come to that in due course. So my answer to my Lord's point is that it is inevitable that there will be national measures. The next...
But then in the next paragraph you have supplemental measures as well.
We do.
Where the foregoing doesn't suffice.
And that's a point which comes out of including Article 13.5, and I will pick that up. The sixth component, and to complete what I have to say from this document, is at 1843. 1843, it deals with development of the river basin management plans. And if I could just, to make the point shortly. This document has a series of text boxes with traffic lights on them. And at 1844, at the bottom of the page, we have one of these text boxes which start out with the imperative to look out. And so they sort of capture key messages. So it says, River Basin Management Plan summarises the results of the planning process. And what it does at the bottom of 1844 is it emphasises that the plan is a strategic planning document and an operational guide to implement programmes of measures that will form the basis of integrated, technically, environmentally and economically sound and sustainable water management within again we have it, River Basin District. And it is in my submission instructive that when the authors of this document are trying to really encapsulate what the purpose is of the river basin management plans, that's the way in which they describe it. They do not describe it by reference to individual water bodies.
Well, that of course is the River Basin Management Plan, which is a separate requirement from the programme of measures.
It is. It is.
If you notice on the same page, under the heading Contents of the River Basin Management Plan, just bullet, general description of the characteristics of the River Basin District, including a map showing the location and boundaries of surface water bodies, groundwater bodies. Is there any significance in that?
My Lord, with respect, no. In that what it is it's a part of the general characterisation of the basin to show the reader of the document where the main rivers are, where the important groundwater bodies are. So
Well, the question is a neutral question. Does it go in either direction?
it doesn't.
I mean, do you submit that it's, but such a reference indicates that actually that's the extent to which the River Basin Management Plan needs to be concerned with surface water bodies, and it doesn't, taking the other references you've given us, go any further than that? I mean, for example, you at the top of the next page, in conclusion, the plan has a number of functions, but primarily it's intended to record the current status of water bodies within the River Basin District, etc. These references to water bodies have no significance, or what significance if they do?
They have no significance so far as the issue in this case is concerned. What we're getting here is some guidance about a general description which is necessary in a plan to assist the reader in understanding where and what the plan is dealing with. It's in no way guidance on the relationship between environmental objectives and individual water bodies within the basin.
Can that be right though? Because if you go back to page 1844,
Yes.
the second bullet point requires estimations of point source pollution following the reference to status of surface water and groundwater. And then the sixth bullet point down has a list of environmental objectives established for surface waters, groundwaters and protected areas, including where use has been made of derogations, and that has to be water body specific, doesn't it? Or am I overreading it?
No, in respect of the plan, it's no part of Secretary of State's case that it's not very clear that environmental objectives are to be produced for individual water bodies. And that is going to be something which is a part of the contents of a plan, and that's something which is necessary within the broader scope of the directive. that the issue here is, what is it that the programme of measures is intended to do, and via what level of specific, I'm never going to be able to say it, how specific they're going to be. So that's the question, and the sixth bullet point that my lord has taken me to doesn't really bite upon that question. But what one gets...
I thought part of the judge below's reasoning, to which you took exception, was the programme of measures should be based on environmental objectives. So, that was part of her reasoning. Can I just take the court through the sequential process via which the framework requires the plan to be produced? And we'll come to it in the document very shortly. But essentially, one is, first of all, characterising. That's the first thing that happens, characterising, including at water body level. The reason for doing that is to then understand what the pressures are. What are the problems in that particular basin? In Spain, is it drought? In the Mersey, is it particular discharges of particular chemicals? What are the pressures? Having done so, what are the measures which address those sorts of issues, including national measures? Then put those together. That produces your programme of measures, which are obviously going to be focused upon environmental objectives. They're going to be necessarily concerned with the pressures and the objectives which your characterisation has shown. But that does not then go on to the next stage, which the judge went to and shouldn't have gone to, which is to say that those measures are concerned with individual water bodies. That's not a necessary part of the framework's requirements. And indeed, I will go on to say that it's very unhelpful in environmental terms. What's needed is a programme of measures at the level of the basin to fit in with what we have seen from the recitals, is intended to be basin-focused, the hydrology of the basin in an integrated way, taking account of the interactions between the various parts of the hydrology of that basin. So, just picking up at what we have at the top of 1845, we have a little conclusion in this regard. In conclusion, the plan has a number of functions, but primarily it's intended to record the current status, so that's assessment and characterisation of the water bodies within the River Basin District, and set out, and these are the words I emphasise, in broad terms, what measures are planned to meet environmental objectives. That encapsulates in a much neater and more succinct way what I was trying to articulate in my answer to my Lord Justice Fraser's question. In broad terms.
Well, that reflects the language of the directive, that the management plan need only contain a summary of the measures. There is a risk of elision in this case. As you follow through the directive, you have Article 5 dealing with characterisation, for example.
Yes.
By the time you get to Article 13, wearily sometime later, you find that the management plan gives you a general description of the characteristics. And the implication is that those characteristics will have been assessed in far more detail by the competent authority than is contained in the document which goes to the Secretary of State or the public.
But I respectfully agree that there's a difference in how fine grained.
Together.
Yeah, and so there is there is, putting it this way, there is a fine-grained characterisation of the basin by reference to water bodies. That's
Were you taking us to any other part of the CIS document?
I don't know whether that was an invitation or a request.
Because I didn't want to interrupt, because I just wanted to see if I'm following this. Would you mind going back to page 1834, which sets up the environmental objectives? And
Yes.
you told us that can be water body focus. And then if we turn on to page 1838, the third component is monitoring programs. Again, we'll look at individual water bodies, I think.
Yes.
And then the fourth component is one which I see in the respondent skeleton, gap analysis.
Yes.
And then that leads on to the programme of measures as the fifth component, which is a freestanding obligation under the directive and under the domestic legislation. Correct?
Yes.
Yes, before you get to the sixth component, which is the river basin management plan.
Yes.
Okay, I just wanted to see if I got the structure of it clearly in my mind. Thank you. The other question I had, you helpfully took us to page 1844, and the sixth bullet point at the very end uses the word derogations. Now, I just want to see if I got the jargon right. Sometimes they seem to be referred to as exemptions, but if you look at Article 4, for example, there is a series of exceptions, exemptions, or whatever to the primary requirements in Article 4.1, timing matters and
Yes.
so on.
Exactly.
Are these sometimes referred to as derogations?
Yes.
Which is no doubt why in individual cases they're required to be referred to in the river basin management plan, because they're that important.
The directive sets up a trajectory via the cycles of planning, and the directive anticipates that there will be some individual water bodies for which derogations are required.
Yeah.
And my lord is, with respect, correct that where that happens, that is to be noted. What the directive doesn't do is tell you what happens when you get to 2027. That falls into the category of things that we don't have to answer today. But
it won't be European retained law if it's a European legislation.
absolutely.
Or
The topic of derogation and supplementary measures to address those water bodies which aren't meeting their environmental objectives is something which does need to be addressed, and particularly in respect of the approach to Article 13.5, which is one of the points that the judge relied upon, and I will do that in due course. To answer my Lord's question as to further references to this document, no, I finished with the document.
and I asked the question before, but has this document been approved by a body within Europe superior to the working group?
I'll take instructions and provide the answer to that.
It goes to its status, really.
Yes, yes.
Yes, I mean, it's published by the Office for Official Publications of the European Communities 2003, it tells us. I'm not sure that's an answer to my Lord's question. Because that office will be publishing all sorts of documents, presumably.
My lord, yes. If we go back to the foreword,
Well, we're told, sorry, in the disclaimer we're told, aren't we, that the views expressed in the document do not necessarily represent the views of the European Commission.
yes.
Doesn't answer my Lord's question, but really,
Well, I'm picking up my Lord's point. I mean, given the disclaimer, it may not have had to have been approved by a superior body if it's just informal consensus position best practice. And when it says agreed by all partners, well, that's not, it's an informal document.
But I've been assisted by Mr. Fraser in, as I have been very much throughout. In the foreword antepenultimate paragraph, refers to the water directors. I'm going to be asked who the water directors are, but I won't have the answer to that. But apparently there are water directors of the European Union, so that will be member states, plus Norway and Switzerland. They have examined and endorsed this guidance by written procedure. In short, everybody's signed up to it, and it's what's applied.
There is another traffic light that we look out at page 1804. Says this has all got to be tailored to the circumstances of individual countries.
And that is a fundamental aspect of the directive in recognising the geographical climatic variation across the member states.
And what may matter here is how our own regulations have been expressed.
That may matter, and it's in that regard that I'm going to start now to make some submissions about point sources, which, as the court will recall, is the second part of my submissions. What I have...
Just before you do, and I do apologise for, because I know we are keeping you on this document probably longer.
Not at all.
But at 1804, final entry, underneath the traffic light that my lord's just drawn your attention to,
Yes.
it says what you will not find in this guidance document.
Yes.
Final bullet point, the establishment of the programme of measures.
Correct.
There will be a specific guidance document. So really, this document is, I think, isn't it, a practitioner's guidance document for what should go in the river basin plan, management plan, rather than what should or should not be included in the programme of measures.
I think that must be right.
Okay, thanks very much.
So, as my Lord or Justice Holgate has indicated in two ways, one is there are national measures, and secondly, just now by reference to the way in which different member states may have their own spheres of regulation which have a particular impact, I want to turn in a bit of detail to point sources. And it's worthwhile emphasising that it is a particular feature of the framework. If in the first tab in the framework itself, we could take our first look at Article 11.
So this is your second main heading now.
My Lord, yes. Next main heading is about point sources.
Yeah, I'm sorry, and the reference you're giving us.
And it's Article 11 of the framework, which is tab 1, page 25.
Just a second. Yeah.
And 11.3G is at the bottom of the page, which is one of the basic measures within the Article 11 programme of measures. And 11.3G is expressly referred to in the judgment below and is concerned with point sources and explains to us that for point source discharges liable to cause pollution, there's a requirement for prior regulation. And an example is given, such as a prohibition on the entry of pollutants into water, or for prior authorization, or for registration and binding rules. which lay down emission controls, including in accordance with Articles 10 and 16. And that these controls are to be periodically reviewed. Just so that we understand the references there to Articles 10 and 16, what Article 10 does is address both point and diffuse sources. So far as point sources, or so far as they are concerned, it's 10.2, there's a requirement that member states ensure the establishment and implementation of, and there we have some alternatives, either emission controls or limits, or for diffuse impacts and good environmental practice, best environmental practice. And so that is incorporated by reference, we've just seen in 11.3G. And just so that we have in mind what Article 16 addresses, page 31, 32, Article 16 addresses strategies against pollution of water, and over the page on 32, 16.8 addresses the topic of point sources and requires that the Commission shall submit proposals for point sources and environmental quality standards. Just pausing there, that's one reason that I referred at the outset to directives prior to the Framework Directive, which address point sources and in particular standards.
Sorry, the provision you were taking us to was 16.
My lord, 16.8, which is towards the bottom of page
I've got
32.
it, sorry. Looking elsewhere.
And it's setting up a process which evolved, by which the numbers were identified by the Commission for emission controls from point sources to produce EQS's, environmental quality standards. And one sees further on in 8 that for substances included in the first list of priority substance, member states shall establish environmental quality standards for these substances for all surface waters affected by discharges of those substances, and controls on the principal sources of discharges, technical reduction. And so what I'm seeking to flag to the court is that 11.3G is drafted on the basis that there are these approaches to point sources and requirements in terms of standards where there is a discharge to a surface water, and that member states and the Commission are developing particular standards for the phosphorus. What is the number? Is it 1 or 5? Or should the substance be banned? And that is what is being referred to in 11.3G. So 11.3G.
I'm not following this. I mean, as I understand it from the submission of OED, Article 16 is requiring further legislation to be passed in Europe, and the passages that you've just been taking us to are examples of them. Is that correct?
That is correct.
Right. So if we go back to 11.3G,
yes,
these are basic measures. Presumably when those new laws come into force, 11.3G will bite on those.
yes.
But before that happens, is 11.3G completely ineffective, or does
No.
it bite? It presumably bites on what we see in Article 10.
Yes, to the
Oh,
in part the
yeah, okay.
the number 105 is something which existed prior to the framework.
I'm sorry, I'm not following where this is taking us.
So it's taking us to the it's taking us to the national measure which is in place through the environmental permitting regulations for England and Wales 2016, which are the regulations which control emissions to surface water via point source discharges.
But the context for this is the opening words of Article 11.3. These are minimum requirements. It doesn't define how far you have to go and no further, so it's not surprising if you find limit values in regulations. That's the minimum you have to do.
My Lord, I don't accept that in the way that it's put for this reason. That what 11.3G is doing is saying have in place a national system via which such emissions are controlled, including by prior authorization. That's permitting. And that is, in respect of many pollutants, a flexible decision-making process. In the particular context of that discharge, what should the emission limit be? On the other hand, agreeing with my Lord's point, that there may be other emission values which are prescribed. Indeed, there may be emissions which are banned, shall not be discharged. And so what we have from 11.3G is the introduction to the way in which in the UK, that particular part of the framework is addressed.
So you say it's dealt with by
The 2016 regulations.
which ones?
The envi-
17.
So the
These the permitting.
is the permitting
Oh, I see.
regulations.
Dealt with in part or wholly? I ask the
in-
question because of what we see in Article 11.4, which says supplementary measures, in addition to the basic measures, are those designed in addition with the aim of achieving the objectives.
Yeah.
So you can't rest on the basis that you've met the objectives you've set under Article 4 without looking at 11.4 as well. May they not be case specific? If the environmental objectives are specific to water bodies?
My Lord, the measure is a system of prior authorization, permitting, which is in the 2016 regulations, which, when implemented, is a measure which is sufficient to enable the objectives to be met. That measure can achieve those objectives so far as point sources are the pressure which is causing a particular effect on a water body. And that's why I said that the application of the permitting regulations is fundamentally flexible and a decision-making process which includes review. And that is what I'm going to go on to illustrate by reference to the way in which the permitting regulations actually operate.
I don't think we have the permitting regulations.
My Lord's correct.
I don't remember this appearing in any skeleton.
My Lord, well, I can answer that point. My Lord goes to the core bundle, please, in respect of the appellant's submission responding to the OEP's intervention at tab 6. Tab 6 in the core bundle. page 318. Paragraph 15, top of the page.
They do find a mention there.
And
Right back to the WFD.
yes,
But maybe I've not followed, but I thought you'd introduced another part of the permitting regulations which are dealing with limit values.
necessarily when the permitting exercise is undertaken, necessarily the regulator will have regard to limit values. And so there is in place a system, as paragraph 15 indicates, which is really part of the meat and drink of what the agency does in this regard, which is both authorise.
Sorry, I really am not following this, and I apologise. But is the thrust of what you're saying that if one were to turn to the permitting regulations and turn up the relevant limit value, so long as there is a permit in place applying the limit value, that satisfies Article 11.3g? You don't need to go any further? Or might you have to do a case-specific analysis for a particular water body?
My lord, it would be the latter.
That's what I thought.
Yes. So there isn't set in stone that the limit values in respect of all matters which need to be controlled via environmental permits. Rather, they are specific to the particular context in which the permit is to be operated. Absolutely. But the submission is that the programme of measures includes nationally applicable measures, and indeed as is required by 11.3g, involves a system of prior authorisation which can result in the control of emissions to individual water bodies to address the pressure which arises from that particular discharge. So the measure is there and can be applied.
Very quick question. Going back to Article 11. 11.3, basic measures. I assume we find them in the 2017 regulations. In other words, not the permitting regulations, the actual regulations that were the subject of
The origin of those is in the regulations, yes.
not the permitting regulations,
Correct.
2017.
Yes.
Over the page at Article 4, 11.4, I beg your pardon, supplementary measures. We would also find those, would we, in the 2017 regulations? In other words, if a higher level than the basic measures is imposed by regulations rather than what the directive requires, they will be in the 2017 regulations.
My lord, no. The answer to that is no, for this reason, that there may be a measure which isn't to be found in any regulation. That there may be a measure which is that there is some funding available to do some education work in a particular catchment, which is a relevant measure, and that one wouldn't find that in the regulations. So, we have, and I've always had, a system for regulating point source discharges. It is correct that there isn't a copy of the 2016 regulations, and we're happy to correct that if necessary. But if we could go, please, to the first bundle of authorities at tab 16. Tab 16 at 474. We have some core guidance from the Secretary of State in respect of these regulations. And these are just extracts from the document. And I just want to draw attention to two parts. 477, the question is asked as to how requirements from national policy and directives are delivered. And at 2.9, we're told that the directives and international agreements contain some requirements. We've just seen that in 11.3G. Second sentence, the majority of environmental quality and specific permitting standards and other related requirements from environmental and human health protection come from directives. The EPR ensure those directives and national policy requirements and outcomes can be delivered through a permitting and compliance system. And it's the environmental permitting regulations, the EPR, which provide the powers and the mechanisms to do that. So the submission is that in order to address both this and some other requirements from, in terms of European environmental law, the EPR exist. And in that regard, it's no surprise at 479 that we have reference to the policy area water discharge activities and also groundwater activities in respect of the schedules to the regulations which control water discharge activities and groundwater activities. So that's a particular indication of how and why the EPR are there. And there is a little bit more detail about that on page 490, which is part of, it's an extract from the first appendix to this guidance document, which addresses the Water Framework Directive. The Water Framework Directive is dealt with in two paragraphs at 130 and 131. And at 131, we're told something about the second cycle of plans. It was produced, approved and published in 2015, and the programmes of measures have been made operational to meet the objectives. Then goes on to refer to the third cycle, and then goes on to say, along with other public bodies, the Environment Agency and Natural Resources Wales are required to have regard to the river basin management plans and to any supplementary plans in exercising their functions in relation to river basin districts. Their preparation and execution may influence regulation of activities under environmental permitting, although it's too early to determine those influences. So far as point sources are concerned, that's the way in which they are linked into the national legislation. And it's worthwhile, if I may, to show precisely how this works within the regulations. This will be our first excursion into the regulations. If the court could go to the regulations, which I think are at tab 2, and in particular go to...
And just before we go off to the 2017 regulations, my view is that we will need the permitting regulation.
I respectfully agree.
So could the parties please arrange for that, preferably over the short adjournment.
My Lord, I can do two things. One is to provide them in their entirety, which will be a substantial document.
Cumbersome.
And Secondly, with slightly more time, I'll be able to provide extracts, which I would seek to agree.
Right, well, agreed extracts, I think, is preferred.
It's a very long
Yeah.
instrument.
No, we'll be guided by you on that. So, agreed extracts of the permitting regulations, please.
So just to flag from the regulations at page 101, one sees regulation 3, which puts duties on ministers and regulators to exercise their functions to secure compliance. The WFD is the Water Framework Directive. And just to complete this part of the submission, just so that the court has it, one goes to page 182. We're there within Schedule 2 and paragraph 31 of Schedule 2 shows the enactments in relation to which there are duties in Regulation 3. So, Regulation 3, comply with WFD, and an enactment in relation to that duty is the 2016 regulations.
So that was page
182.
182.
I'm grateful. Before going any further, I just want to say something about the way in which permitting is necessarily set up in the domestic sphere of regulation, and that's to do that by reference to the case of Markich, which is at tab 10 in the authorities bundle, which I believe is the first authorities bundle. Page 324, tab 10, the case of Markich and Thames Water. Where this is a case which is concerned with flooding from sewers, and it's a case in nuisance in which the House of Lords had cause to set out the scheme of regulation of the water industry, and that is done by Lord Nichols at 333 of the bundle, paragraph 10. And the point to which I want to draw the court's attention and the submission that I want to make is that from paragraph 12, that the Water Industry Act of 1991, paragraph 12, the Water Industry Act of 1991 is extensive. Part 1 of the Act makes provision for the offices of the Director General of Water Services. That is more frequently known as Ofwat. And just above D, it's explained what happens. In short, the Director is the regulator of the water industry in England and Wales. He is required to exercise and perform his statutory powers and duties in the manner he considers best calculated to secure that the functions of a water undertaker and a sewage undertaker are properly carried out. It includes ensuring that companies appointed as sewage undertakers are able, by securing reasonable returns on their capital, to finance the proper carrying out of their functions. Commercial companies cannot be expected to take up appointments as sewage undertakers unless there is a prospect of obtaining a reasonable return on their invested capital. The Director is also required to protect the interests of customers of sewage undertakers in respect of sewerage undertakers' drainage charges and in other respects. And so the scheme of regulation that we will see when we come to programmes of measures is that there is, first of all, for water companies to identify the assets which they can or should improve in order to provide appropriate treatment of wastewater and to address environmental issues. And that's an asset management plan which is carried out every 5 years and results in a price review by Ofwat. Last one, price review 2024.
Did you say the water companies identify the assets which should be so improved
Yes,
in order to justify the setting of a price, taking into account their rate of return?
yes. Along with the production of a water industry environment programme, the WINEP, which is a matter of some discussion between relevant interested parties as to what improvements are necessary. So if there is a eutrophication problem, if a river is receiving nutrients at a rate at which it is giving rise to algal blooms, causing the oxygen to go out of the water and the fish to be killed effectively, then a factor in that might be point source discharges from sewage treatment works or other point source discharges which require those permits to be amended and necessarily the sewage treatment works to be upgraded. And all of that is captured within an asset management plan, and then the balance is struck by the regulator as to the works proposed to be undertaken and the available funding via the price that's set. And so that's the structure which is set up within the 1991 Act as between the environment, the infrastructure and the costs. And it's adjudicated upon by Ofwat. And it's important to have that in mind when one comes to consider the way in which permitting is then undertaken. So that the permitting regime is one which, of course, is started via the application for a permit, but includes review, which can be initiated by the regulator or may be required, for example, in cases where there is a European site which is affected. So that,
Regulator in that context would be the EA.
yes, in England it would be the EA, and in Wales, NRW. And that process of permitting is in fact subject to a right of appeal to the Secretary of State. So if the regulator says we're going to review your phosphorus permit from 5 down to 1, there is a right of appeal to the Secretary of State. To the Secretary of State. With that in mind, it's worthwhile to look at what the Office of Environmental Protection had to say in respect of what is being achieved and what can be achieved in respect of environmental objectives. And as the court will have read from the core bundle, if we can turn please to the core bundle, the OEP at tab 5 has provided both submissions and a copy of its report. And in that regard, it tells us something about, firstly, the extent to which there's been success, and also in respect of costs. So far as costs are concerned, in this, using the through pagination of the bundle, at 198199, we see something in respect of investment requirements.
Have you got a paragraph?
My lord,
This is not the submission, this is the.
my lord, this is
extracted, but this is a report, is it?
my lord. It's a report which I should have introduced more fully if, from page 122 of tab 5. 122 of tab 5 is the frontispiece, which explains that this is a review of implementation of the directive and river basin management planning. And it's focused on England. And so this is a report which was produced in May 2024. And I'm going to take the court to chapter 4, 189. Chapter 4 at 189 is concerned with effectiveness and I'm going to, in that regard, show the court something about costs. So turning in this document to, you can't actually see very easily 198, it's 198, 199. 198, there is a heading, investment requirements for the programmes of measures. And one sees recorded there some material from an environment agency published analysis of investment requirements to accompany the third cycle of river basin management plans. And the short point is to be found in the sort of solid text box which deals with those investment requirements and indicates that achieving the environmental objectives would cost £51 billion, providing £64 billion of benefits. And those costs exclude ongoing work to prevent deterioration, to which a number of £5 billion is attached. So the reason that I took the court to the scheme of regulation of discharges by point sources is that there is a scheme of regulation which holds the ring as to what investment takes place where and to what end. Point source discharges are not the whole narrative, of course, in respect of investment requirements. That's very far from the case. But I'm trying to focus on point source discharges for the reasons I explained. But the short point is that to get to a point whereby one is reaching the environmental objectives, it requires a sum of money which is startlingly large, indeed eye-watering. And for that reason, it's worthwhile then going back in the same document to the extent of success, both in England and elsewhere. And in the previous section, we learned what the position is. So just so that I'm introducing this properly, chapter 3 starts on page 173 and it's concerned with the water environment in England. and I only want to make two short points from section 3.3, which shows how England compares with other jurisdictions and nations. And one sees this most effectively from page 182, which again is difficult to read. Page 182, which is 3.3.2 and has a figure 3.5. I invite the court's attention to figure 3.5, which shows the percentage of water bodies at good ecological status or potential across European countries at the stage of the second cycle river basin management plans. And we see maybe 2/3 of the way along the list, the United Kingdom, and we see that the bars along the bottom, that they show the percentage of water bodies at good. There is a bar along the top which shows us something else. That shows us that by the bar, the population density in the particular state. And the idea is that you can get some sort of gauge as to how population density might be a factor. So the 64%, I think, is the population density, and the bar shows the population density as against the right-hand axis, showing a little bit less than 400 per square kilometre. That's for the United Kingdom, not for England. The number's bigger for England. And the percentage shows percentage of the land in agricultural use. So that's kind of a measure for pressure in a way. How much agricultural use, what's the extent of the urban areas, etc. So what one gains immediately from this graph is that no member state in Europe is meeting the objectives in the directive. And we see that stated in words a couple of pages earlier, at page 180, where we have bullet points set out with key facts. And the fourth bullet point is that none of the 27 EU member states has yet achieved the objectives of the Water Framework Directive.
Sorry, that's
Page 180, which
yeah, I've got it now.
and there's a dark text box, key facts,
Found it.
fourth bullet point. And just for context, the penultimate bullet point, performance of the UK is similar to that of countries with broadly similar river systems, physical geography and pressures for agriculture, urbanisation and industrialisation. It exceeds that of 9 EU member states. So that's a little commentary on pressures and extent of success or failure. And I draw attention to these matters because the framework requires that measures are put in place which can get to the environmental objective. The remaining question is whether or not those measures are capable of being implemented to achieve that objective. And one can perhaps see from these numbers and the fact of 27 member states not achieving the objectives that the authors of the framework were right to describe it as ambitious. It is ambitious.
So how does this help resolve the central question that you identified as being before the court?
In this way, because the programme of measures is there to ensure that the measures are in place so that this can be met, that environmental objectives can be met. The measures do that. There is then a question of implementation and being able to implement them to a degree to reach the objectives. And that, as this report so carefully illustrates, shows that that is a major challenge which nobody has met.
Yes, no doubt. But how does that help us to decide whether the programme of measures should take into account effects on individual water bodies?
It assists because the way in which the measures are made for the particular river basin district is intended to provide the measures which can achieve those objectives. And
I mean, you're not suggesting, are you, that because there is this mechanism enforced by Ofwat, described in Marchik, that the programme of measures requirement in the directive and 2017 regulations can be left to that other statutory regime? I don't think that's what you're suggesting, is it?
no, it's not. No.
And in any event, that other statutory regime, the Ofwat regime, depends on building up a cost which is to be funded by prices, charges to consumers, which is a combination of all the individual schemes. It does descend to deal with water body level.
Yes, and that very much supports my
Why does it follow from that? That it, as a matter of statutory interpretation, the regulations we're concerned with don't require that in the programme of measures.
because
Some might say it would be a useful input to the Ofwat mechanism.
the essential answer to that question, my lord, is that it's because it's inevitable and clear on the face of the directive and the way in which the measures are drafted in the national legislation necessarily involves other actors, necessarily involves other decision makers. And to have a programme of measures which says this will produce this result is plainly something not within the gift of the Secretary of State, because others are making very important decisions as to what goes where, albeit that they will be having regard to the plan. They will be working together. It's not working against, it's working together with the plan, informing their decisions as to which permit they're reviewing, to what extent, to promote the objectives of the plan. And that might include some prioritisation. It might be that, that protected areas come out ahead of other water bodies, by which I'm meaning those areas which are protected as habitats regulations sites. The River Wye is a good example. It may be that there's prioritisation going on there, but that is going to be decided by others, and the scheme of the legislation makes that absolutely plain and clear. So that is why I make the submission that it is for the programme of measures to ensure that that can be done.
How does it do that if the programme of measures is done on a national level? Or, I beg your pardon, I'll put it slightly differently. I go back to the declaration that the judge made, which was the periodic review of the programme of measures under article, etc., to be done at the individual water body level as opposed to river basin district level or national level. So to achieve what you've just been quite helpfully explaining, that level of detail at water body level would be required, wouldn't it? Because otherwise that prioritisation exercise can't sensibly be done.
But the premise to my lord's question is that the plan is doing that prioritisation.
Well, no, the premise to my question or observation was based on the declaration by the judge, which obviously the one you're challenging on appeal,
Yes.
which is that the programme of measures effectively has to be done at the individual water body level rather than the higher, whether we call it river basin, district level or national level. Let's just say the higher level rather than the higher level. So in order to perform what is undoubtedly required, as you've explained, which is the prioritisation exercise to balance resources, expenditure, need, etc., objectives, one would need the individual water body level detail in the programme of measures.
My lord, that's a very important question, and the answer to it is fundamental to the case. And the answer to it is that, firstly, that the programme of measures is not exclusively concerned with national measures. I'm focusing here on the EPR of 2016. But as we will see after lunch, there are measures which are specific to particular areas or basins. And so that's the first point. But the second point is to recall what the framework is seeking to do for the River Basin District, which is to analyse and characterise and understand what the pressures are. Analyse, characterise, understand the pressures. And the value which there is in having a programme of measures of the sort which the Secretary of State approved is that the agency and the Secretary of State stand back and say, for this basin, what's the range of measures which we need to have in place? Stand back for the whole basin. That's the value of it. It would diminish the value of that to be in a position where you're looking at some thousands of individual water bodies, because that then is a question for implementation. And this is the last point in answer to my Lord's question. The implementation is being undertaken by others, having regard to the plan. And the plan is telling others what they're trying to achieve and what the toolbox is to seek to achieve it. And that is an absolutely typical strategic plan. There's strategic plans in all sorts of disciplines which do exactly that, and strategic plans in all sorts of disciplines which show differing measures of success when those policies, instruments are put into effect. Before I complete that answer, I want to make it absolutely clear that none of that is to understate the importance, the environmental importance of the work to achieve the environmental objectives for each water body. I'm not here to set up a difference between the overall ambition of the Secretary of State and those who are affected, such as the association. What I am here to do is to make it very clear that the Secretary of State values the overarching approach by reference to river basin districts and measures which address the pressures which have been found to characterise that particular river basin district. Which gets me to 1:01.
The central issue in the appeal affects not just the interpretation of the 2017 regulations, but before you get there, the directive itself.
It does.
Are we supposed to be interpreting the directive by reference to the particular national mechanism we have in this country for setting the price of water for consumers?
My Lord, my answer to that question is that we are occupied with the regulations, which necessarily requires that we interpret the regulations by reference to the directive. But to answer my Lord's associated point, the means by which directive is put into effect in England is necessarily an important part of the interpretive exercise, not least because they cross-refer to each other, as I've shown the court from the 2016 EPR. And necessarily, that does require that regard is had to the operation of other schemes of regulation, such as that in respect of the water industry. So it doesn't go as far as to say that one interprets the directive by reference to the Water Industry Act of 1991. It is relevant to and important to understand the programme of measures, which is at the heart of this.
The programme of measures under the 2017 regulations has to be prepared by the EA and approved by the Secretary of State.
Yes.
Do either of those two authorities have any statutory role under the 1991 Act in relation to the setting of water prices?
The answer to that is twofold. Ofwat sets the price.
Yes.
The basis on which Ofwat sets the price is on the evidence which is supplied by water companies and with representations from others such as the agency. This is a scheme we need. This is a scheme we don't need. And that's necessarily going to be instructed.
But the programme of measures is approved by the Secretary of State, not the agency.
And of course, the Secretary of State is also the appellate body in respect of environmental permitting. So there is an interaction already there.
Right, now it is 1 o'clock. We've covered 2 of your 4 main headings, I think. The third of your 4 main headings was in terms of the Water Framework Directive itself. And you're going to come to that next.
Next is the framework's terms itself.
Yeah. Bearing in mind that you characterised the issue at the outset as does the Water Framework Directive require a programme of measures to be undertaken for individual water bodies? Shortening and paraphrasing. So your third heading is squarely addressed to that issue, as I understand it. All of that prompts me just to remind you that timetable is important, and no doubt we have a living timetable.
And we've had a number of very helpful interventions which have assisted in that.
That's kind of you to say so, but it's inevitable with a hearing of this kind, as you know very well, Mr. Kimden, that we will be asking questions. So please just consider timetable and proportionate use of what's left.
Yes. Can I say that Mr. Fraser and I have taken the opportunity of considering together how matters are to be set out, and we are on target.
Good. Thank you very much. We'll start again at 2:05. Thank you.
Court